What's up, everybody? Welcome back into another week, and yet the same trial continues. YSL. And all the co-defendants here, Young Thug included, are still on trial. They're still going through witnesses. They're still discussing exhibits. They're still discussing recordings and redactions and what evidence is coming in and what evidence is not coming in. And still many, many witnesses to go while the defense has had enough. And they filed a motion telling the judge that she needs to cap or limit the state's time in this case. Limit either the amount of witnesses or the amount of days or the amount of hours that they have left. And we've seen this happen in civil cases. We've seen it discussed in criminal cases. And we're going to talk about where the lines are actually drawn. We're also going to discuss some political statements made by potential state attorneys in the jurisdiction about this case and what they think should happen with this case. And of course, we're going to answer all your questions. So please hit the like button and make sure you guys subscribe if you have not already. So, Dad, the never-ending story continues and the YSL trial continues. I think this is another week without the jury there now to discuss evidence and recordings and redactions and exhibits. But before we get to kind of what's going on in the trial itself now, I thought it was important because a bunch of people tagged me in this. I posted it on Twitter. Thugger Daily, I think, was one who posted this. And it's an official press release from Courtney Kramer for District Attorney, Fulton County, Atlanta, Georgia. The following is a statement from Fulton County District Attorney, Republican nominee Courtney Kramer regarding the ongoing YSL RICO trial. As the Republican nominee for Fulton County District Attorney, I have watched the ongoing trial and endless prosecution of YSL with no apparent justice in sight. I have become highly concerned and disappointed in the lack of prosecutorial oversight in this case. So just to give you guys kind of a frame, she is running to be the new DA against the incumbent DA Willis in Fulton County. And so she's going to take shots at the current prosecutorial oversight and team, and this case specifically, which is obviously high profile and has been going on forever. As time goes on, the public has tirelessly witnessed a trial that is undoubtedly over-prosecuted by attorneys who have repeatedly been admonished for their lack of trial preparation, a complete and utter waste of the court's time. Prosecutors even had one judge condemn the state for not following the ethical and legal duty to disclose exculpatory evidence that could prove fruitful for the defense. One of the most basic requirements in the courtroom, with more than 180 acts listed in the indictment, with 28 defendants, this case was brought to bring fame to the current DA, Fani Willis, not to bring justice to the community. So those comments initially, again, make you think, does she think they're actually innocent? Does she think this is just unfair? We'll talk about her experience. We'll talk about her political affiliations. Obviously, there's a mix of that. And then we'll also talk about if this is even unusual in races like this. So, Dad, just wait, hold. I know you have comments on it. I'm just going to finish reading, and then we'll dive in. I am absolutely dumbfounded as to the motives in spending endless amounts of taxpayer dollars on a prosecution that is based almost entirely on witnesses with little to no credibility. Who do you think she's talking about there? Not only have I lost any ounce of faith faith that justice is in fact being served and the people of Fulton County are being advocated for in an ethical and transparent manner, but this case should have ended by now. Even former DA Paul Howard declined to bring this case, and now the public can see why. Okay, she's bringing all sorts of stuff in, right? That it's unfair, that it's too long, that there were Brady disclosure issues, that the prosecutors are unethical, and that the former DA decided not to bring charges. All right, last paragraph, two paragraphs left, and then we'll let you ride. If I am elected as the next DA of Fulton County, and this is underlined in bold, I promise to end this prosecution immediately. I challenge my opponent to do the same thing, the right thing, and end this prosecution and release those who are accused in this case and who are being held without bond. If elected, I intend to restore justice, transparency, and integrity to the office of the district attorney and the dismissal of the YSL case will be my first official action toward that goal. Fulton County citizens should feel safe in their own homes, parking their cars on the street, and shopping in their own communities. Victims of these crimes should know that their elected prosecutor prioritizes spending taxpayer dollars, clearing the backlog of those kinds of cases, and not prosecuting cases for media attention. This is not about right versus left. Okay, she even mentions that. This is about right versus wrong. Above all else, this is about the future of Fulton County and holding accountable those who are elected to serve and seek actual justice. So, Dad, now I have a few questions for you based on this. Let's put aside the fact that she hammers the delay, how long the trial has gone, how unorganized it is, how unfair it is. Let's put all that aside because we're going to talk about that with the motions and what else we have. How common is it for district attorney races to get this public and for them to pick out high-profile cases or different cases they disagree with how the prior administration handled them?
Well, it happens all the time. It is extremely effective. People have lost elections based on the public's perception that they didn't do a good job or they messed up on a particular case. I mean, not just state attorney elections. We've had years and years ago, some people may remember, happened in presidential elections where a guy was running for president and he was governor of a state and he pardoned somebody that that the public didn't like him pardoning. Well, his opposition said, oh, this guy lets murderers out of prison because he pardoned this guy. It was very effective. It may have even cost them the presidential election. So it is very common to bring up, and it's legitimate, to bring up their actions while they were in office to show that they should not continue in office and that it's time for a change. And so that's very common. I mean, she cites legitimate things in here, but it's very common to try to use those things against the incumbent.
All right. And before we get to your negative feelings on the comments, I think it's fair game to look at somebody's past work and their experience and what they've accomplished or not accomplished in addition to their resume when you are running against them. And I think that's perfectly fine to say, this isn't how it's supposed to look. The whole world is looking at this and saying it. Everybody watching this has been saying this to us for weeks and weeks and weeks and weeks and months about how unfair this trial is. And this isn't what prosecutorial professionalism is supposed to look like. Almost just regardless of if the charges are correct or if these defendants actually committed crimes or did anything wrong, the discussion has not even been around that. And that's one of the problems with this case. And I think that's a fair thing to discuss, that we can't even know, even if these guys are convicted, we can't know if justice was served because of how the prosecutors are acting.
Well, it's even more significant in this case in that Fannie Willis, the person prosecuting it, is the chief assistant. So it's not just some underling assistant.
You mean Love is Fannie Willis's chief assistant?
Right. Did I say that wrong? Okay.
You just made it sound like you said Fannie Willis was the chief assistant. I just want to make sure that was clear.
Fannie Willis's chief assistant, Miss Love, is prosecuting this case. That's particularly significant because who is more important, who is more in sync with Fannie Willis than the chief assistant? So she can't run away from the actions of these prosecutors by saying, oh, these are just some low-level prosecutors, they may be rogue prosecutors. I've got a big office, so how can I supervise everything every little prosecutor does? You can't say that about Miss Love, considering she is your chief.
Yeah, and she's made statements about it. And again, the prior DA did not bring charges. She decided to bring charges. It was an intentional decision. And again, if she believes crimes are committed, she's protecting the community. That's a decision she has to make. And that decision could have been proper and correct at the time, and it could have just gone bad with the prosecution. Sometimes that happens, right? And then you have to make the decisions and you have to adapt. But what are your negative feelings about Courtney Kramer, this person running for it, about how she said she would dismiss the charges on day one? What is her experience like? What is her background? We'll get to politics later, but just her as a candidate doing this and saying, if I'm elected, I'm dismissing these charges.
Well, that's irresponsible. Even in her statement, she says the public should feel safe in their homes. Well, maybe these people did commit the crimes. I don't know. But until you become the state attorney and still you become, all the facts and you've talked to all the witnesses, how do you know that they did or didn't commit these offenses of racketeering? So the fact that before you know all the facts, you're making a judgment. You may let guilty people back on the street, number one. Number two, maybe you're going to get some big campaign contributions now, since you made a statement saying, I am going to dismiss this case. Well, who knows if the thug's not going to start writing some checks to Ms. Kramer here for her campaign, because if she gets elected, I get off. So what kind of a system is that tells a defendant that's on trial, look, I'm going to let you off if I get elected? You can't do that, and it's irresponsible to do that.
Yeah, I think it's one thing for us to sit here and watch a trial and talk about how unfair this is and how potentially this could be a mistrial or charges dismissed, and a judge that's sitting in trial, seeing all of it, experiencing all of it firsthand, making that decision. Okay. That's fair game. But for somebody who's running for a position, who doesn't know what's in the files, who hasn't talked to everybody, to say they would do something, again, may be a bridge too far. I'm not sure. I think we've seen a lot of this case that looks horribly bad, looks completely unfair, looks like these guys' constitutional rights are being violated left and right. So, I understand why she's annoyed or frustrated with this, but at the same time, it is a bridge too far probably to go in and say that, even though she doesn't have the files, she hasn't talked to all the witnesses, but she's seeing the terrible things that we're saying, I'll just say.
Right.
And then you also said that she's not super experienced.
She's been a lawyer for 4 years. I don't think she's ever done a criminal case. I don't think she's ever prosecuted or defended a criminal case. I don't see how, frankly, she's qualified.
So we're just saying he hasn't done a lot of research, just qualified
Right.
if you're not positive.
Right,
I don't know that. I don't know her at all.
The 4 years is correct.
Right. Okay.
She's only been a lawyer for 4 years.
Okay.
Yeah. So I know that's correct. And I gotta say another thing too. Once she's in office, she can look at this case and say, use their prosecutorial discretion and dismiss this case. I've had cases where my client maybe was guilty, I'm not saying, but that the state finally decided it just wasn't worth prosecuting the case, that it wasn't worth the time and effort, so they dismissed the case, even though my client may be guilty. She has that discretion once she's in office. But to say that before she's elected, you're right, a bridge too far.
Right. And then, of course, we're not going to get into the politics, but she may be connected to candidates on the right side, and, other people may be connected to candidates on the left side. And of course, that's part of it that people are going to discuss, that you can, make your own judgments on and your own thoughts on, that we don't really need to dig into very much.
Well, and the other thing too, she's the first Republican candidate for that office in 30 years. No Republican ever wins in Fulton County. So hasn't even been a Republican running. Whoever the Democratic nominee was automatically got elected in Fulton County.
You said
so
30 years?
At least she's plowing new ground.
In 30 years, it's been like that, you said?
30 years.
Interesting. There's just so many interesting. My initial thoughts on that are like, that doesn't seem to always make sense with how politics is supposed to go, but forget it. We'll move on from politics. And in that press release, she talked about delays, lack of prosecutorial oversight, issues with how the prosecutor's been handling the case. It's an endless case. It's just going on forever while these defendants are sitting there without bond. Okay. And the judge has talked about how the prosecutors are either unethical or unorganized. So we're going to listen to a clip. I think this was from Friday, but this is leading up to where even the judge is seeing, the new judge, I should say, is seeing how unorganized and problematic this prosecution is. And the defense continues to make these arguments day after day until eventually they file a motion to limit the time. But we're going to listen to this clip first. Then we're going to read the defense's entire motion.
Cards face up on the table. It is, I may want to introduce it, but not if it's going to be otherwise inadmissible. And so I just don't, we've been proceeding like it's a fact that this is taken on January 10th. How do we know that?
So with or without the
Or I'm sorry, not taken, the posted.
What's your basis for asserting that it is posted on January 10th?
I don't know when we've asserted that in trial. This is a picture that we served. It has the January 10th date on it. I don't believe I have ever communicated that we believe or disbelieve that this was taken on January 10th. I think our understanding, and I'm just confirming, is that we believe the picture itself was taken prior to the 10th, but it might have been posted.
I understand.
But whether or not it was on January 10th or how this date arises.
Okay, well, number one, you need to figure out why that January 10th is on there. And number two, if it wasn't posted on January 10th, what's the relevance?
We agree, and that's something that if we decided to enter, we would have determined that. I don't know if this is the picture that we were going to enter, so it's the voluminous amount of information. I don't know if this is a picture.
Right, because y'all haven't exactly organized your case yet. All right, Mr. Shar.
So a little side comment, a little snark. Y'all haven't organized your case yet. There's a little bit more coming just in this short clip, multiple comments like that. The prosecutor tries to, give something back, but the judge has already moved on.
They don't know whether they're going to use it or not. And they don't seem to, it would not at this point be admissible, but I can't tell you if it might be admissible at some other point when they get their case organized.
And you're right, it's not about the case not being organized, it's about whether or not we were using this particular piece of evidence. Like there we have a multiple of social media.
Right. Well, you don't know whether you're using it, and you don't know whether it is relevant. So
this is obviously a long case. It's obviously a difficult case to prepare, but at some point, what exhibits you're using and you're not using, and they are a year into this case, and they're still saying they don't know if they're using certain exhibits.
Peter, this is unacceptable. I mean, I've got to tell you, the fact that this is a long trial is no excuse for the prosecutors not being organized. They have all the resources they want. There's 3 of them sitting there at the table. Who knows how many investigators and law enforcement agents they have working for them? Who knows how many paralegals they have working for them? There is just I've been in trials that have lasted 6 months or more. And I've been a defense lawyer in those trials. And the prosecutors had everything organized, all in a box, all in the numbers. Everything was ready. Bam, 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 bam. And there's just no excuse for this.
Yeah. And I can't imagine how it's unfair for a defense attorney to say, Judge, my client's life is on the line here. Can they just give us the exhibits they want to enter? We're watching the Sarah Boone pre-trials. We're watching all these cases pre-trials where everybody's got to get everything in order. Here's exhibits 1 through 100, whatever it may be. Here they all are. We may not use all of them, but here's what they are and here's how they're relevant. And if you as the prosecutor can't tell them on day one how this picture is going to be relevant, it should be out. The judge is even the judge here said, well, it could become relevant later, so we'll see. I'm not going to strike it. It's Judge, if they can't tell you why it's relevant a year into the case, are they just going to be able to find some way to make it relevant later? How am I supposed to prepare for that as a defense attorney?
Well, the judge can't rule until they actually put it into evidence. That's when the judge will make their ruling. So what they're doing now is this is all pre-trial, and they're trying to give a heads up to the defense lawyers, and the judge will order them to do this, to do the witnesses they're going to call, what those witnesses are going to say, and the evidence. And they're just not ready.
But if you're prosecuting a case and you have a picture and you say this might be an exhibit and I object, and I object relevance, and you can't explain what the relevance is, so everything is just open until you try to enter it in. You have to have a limited number of exhibits that you're even potentially going to bring in. And if you're going to potentially bring it in, you should be able to explain how it's going to become relevant.
If you list it as evidence in the case, then yes, at that point, they can argue whether it's relevant or not.
Right.
What I'm saying is until they list it, I don't know if this is listed or not. I don't know what the story is with this picture, but the fact is they can't say why it's relevant. The defense can't argue relevance or not relevance because the state can't say why it's relevant. This case is a mess because of that.
Britt said it's Fawny, not Fanny. That's my bad, Britt. I did not know that. I haven't heard it said a bunch, just read, and in my head, that's how I read it. So that's my bad. Our bad, Britt. Rebecca said, how is it fair to these defendants to have these attorneys FAFO while they sit incarcerated? So F around and find out is what that means, I think. So this is something, Rebecca. So the motion hits directly on this point. So I'm going to hold it. I'll answer. We will for sure answer this when we read through the motion. Let's listen to another minute or two of this, and then we'll get to the motion. So, okay, hold on. Another thing real quick. Miku said, this is pretrial almost a year since openings. Yeah, they're still handling pretrial issues in the middle of trial. That's how you know how bad this is. And that's why it's just like, it's gone too far.
Because you don't know when it was posted. Relevant. So because you don't know when it was posted or why you think January 10th is on there. So we just don't know. So
Your Honor, in the
Date on the post, and they don't know why or how they're going to prove it or who's going to testify to. I mean, that just seems like so many judges would be like, no, you can't use it if you can't explain this at this point.
previous motion, the state asserted it was posted a couple hours after the killing of Donovan Thomas. So if that is not the case and they cannot assert that, I would ask that this post be deemed inadmissible because it has no relevance and it.
I'm not going to deem it inadmissible because maybe at some point during their case, they'll come up with why they think that. Do you know what motion it was in? Maybe that'll help Ms. Hilton get to the source of.
It was argued in front of you.
Yeah, I remember that.
Okay. I'm trying to remember what brought it up.
Maybe it was Ms. Love. I don't know. Maybe you need to speak with co-counsel.
Yes, I'm trying to, I believe we were going through the proposed exhibits upcoming and I brought that up, but.
Yeah, you brought it up. I don't think we have gone through much social media yet.
So you get kind of the gist of the back and forth, the issues the judge has. Dogbone said, haven't been following this case much, but has a jury actually been serving for 8+ months or about 8 months? How can they afford to live if they're not working? So this jury's been in and out. They're there for a couple days, gone for a couple days, there for a couple weeks, gone for a couple weeks. It's brutal. It's unfair. It's not how it's supposed to be. It's not how it's set up. It's not an efficient use of resources. But I mean, it's just something that the system has to account for, and jurors have to serve on juries, and it's part of their civic duty. And most states have laws in place where they can't lose their job for jury service, but hardly anywhere makes sure they keep getting paid if they have an hourly job or some kind of job that, you know, doesn't allow them to get paid while they're in jury service. So it's really tough in a situation like this. All right. Anything else on the clip?
No, but you can see she is putting off making a decision.
Correct. Which is not unusual for judges.
Right.
All right. Lastly, we will bring up the motion filed today at 12 a.m. So technically today. And it is the motion to time limit the state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. Just off the title, what is your first thought of defense attorneys doing this? They're not just asking for one thing, right? He's asking for a lot of different things, but there's also a lot of different remedies that could come from a motion like this.
Right. Well, my first thought is that, well, Mr. Weinstein files very good motions. They are well written. They're thought out. They sound really nice. The odds of success, when I see this, I don't think he has a real good chance of success. But what he is doing, I think, is he is setting up the judge's mind. He's setting up mentally for the judge. Judge, you may not grant this motion, but I want you to think about all the things I raise in this motion as we go through it, and keep that in the back of your mind, because when I make objections later on, you're going to remember, aha, I remember that motion, and aha, I'm going to do something about it. So they're doing something here. It's a psychological ploy to get into the judge's head and to alert the judge to what's coming up in the future.
Yeah, and I think that's the point, is every time something comes up that's cumulative in the future, he can reference back this motion. Every time the judge says they're unprepared, he can reference back this motion. Every time he thinks they're wasting time, he can reference back this motion. And even if you lose, This builds the record and builds credibility for you. And you can be like, I said this was happening. I knew this was happening, Judge. This is so unfair. I've already filed a motion. You can file a second motion. So we do that a lot of times in cases when discovery is late in civil cases, and it happens over and over. And they turn it into us the day before the motion to compel hearing happens. And it's just not fair. And it's not the way it's supposed to go. It's not the way the rules are supposed to go. And the third or fourth time, sometime the judge will sanction the defense. So it's building up that record. And like you said, working on the judge's mind. The defendant, DeMonte Kendrick, by and through his undersigned counsel without waiving any other rights to which he's entitled, files this motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. As this court has broad discretion to exercise reasonable control over the prosecution of witnesses and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness, inefficiency, presentation of cumulative evidence, causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. Simply put, the court should put a reasonable time limit or clock on the remainder of the state's case. So poor decision-making by the jury is an interesting one, that he's worried that that's going to be a side effect of all of this. And then his footnote says, a similar but not identical motion requesting limited the number of state witnesses to less than 400 was filed with Chief Justice Glanville in March of 24, and the judge granting some limited relief, which was generally has not been followed by the state. So they had to make lists. They had to tell them who was. So there's already been certain limitations put on the state. They're asking for more. The state has put and continues to put this court, these defendants, and these 16 jurors through the arduous, tedious journey. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on and trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes, and that the finish line of their snail-like marathon is in sight. That's some of the verbiage you like. At this point in time, this honorable court has borne witness to the state's unpreparedness and lackadaisical attitude toward any type of diligent approach to moving in a deliberate fashion towards a conclusion. That was the clip we played. The judge literally said it. Did you have something you want to say?
No. Sorry.
Why should the state have any need to move with deliberate speed? The state returns home to their friends, families, and loved ones at the conclusion of each day. The state lives their lives, goes to work, gets their paychecks, no matter how long the trial proceeds. Meanwhile, for Mr. Kendrick and other defendants, every day is Groundhog Day. But instead of waking up to the Sonny and Cher, he wakes up to the cacophony of Rice Street and the ritual of heading to court. So that's a throwback to the movie Groundhog Day, in case anybody hasn't seen it. So how is this fair? Like, your thought that the state can just endlessly go on, like Rebecca asked, can just endlessly go on because every day is, a normal day for them. It's just a job. And then she said, see. So how do you think this is fair? How do you explain this? Because this happens sometimes in cases, even when there's not prosecutorial misconduct, when there's a 2, 3, 4, 6 month trial, it's the same thing. So why is it fair in some cases and not in others?
Well, I think, again, this is not a motion for bond, but I think that this is a setup. This is a getting the judge's mind right, because there is case law. There does come a time when their incarceration does become constitutionally improper. And the fact that the state may be delaying, may be causing them to be in jail because of how they're prosecuting the case, that may be a reason to constitutionally give these guys bond and let them out. So I think this is part of the setup.
Let me see here. Okay. And then he's going to cite some case law. The U.S. Supreme Court has explained the critical role of the trial judge in a criminal case. Our cases have consistently recognized the important role the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but determining questions of law. A criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this must have broad power to cope with the complexities and contingencies inherent in the adversary process. To this end, he may determine generally the order in which parties will adduce proof, His determination will be reviewed only for abuse of discretion. The judge may refuse to allow cumulative, repetitive, or irrelevant testimony. If truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. Now,
let me stop there if I could. I want to point out that cumulative, repetitive, irrelevant, those are trial objections. Those happen during the course of a trial when the state tries to introduce evidence, then defense lawyers object cumulative. Then the judge makes a ruling. Asking the judge to rule in advance, that's the problem with this motion.
yeah, and I think that cumulative, repetitive, or irrelevant is the hard part, right? So he's saying limit it, time limit it, limit the witnesses, do this, do that. But it's like, but you're also realizing that in order to do that, she has to find that they are cumulative, repetitive, or irrelevant. And it kind of feels like they're arguing both things, like just like you said, almost blindly limit the witnesses or time limit them or whatever. So trying to find a happy medium, do you think that's something even a trial judge has the authority or discretion to do, where they could say maybe not call anybody cumulative or repetitive because she may not know that yet, but say you have 6 months to try this case and then it's over? I mean, I think they have discretion to do that, but what kind of findings would she need to make in order to make that appropriate?
It's very tough to make that finding in a criminal case. And because, again, there are constitutional issues involved. Secondly, we're in the middle of the trial. So telling the prosecutors now that they have 3 months left, as opposed to telling them, again, understand the difference. If you tell me before I start the trial that I have 6 months to present my evidence, then I can plan the 6 months. But now maybe there are witnesses I put on that I wouldn't have put on if you had told me in the very beginning that I had a limited amount of time. But telling them in the middle of the trial that you're going to limit their time, that makes it particularly difficult for them then to make judgments, because then you interfere with their trial strategy and you really are not supposed to do that.
Yeah, and the judge shouldn't tell either side how to try the case, what witnesses they should or shouldn't call or can or can't call necessarily, as long as there's not, prosecutorial abuse basically happening, which some could argue it is here. But I will tell you, the only pushback I'd have to your point you just made, if I was a defense attorney on this case, is it's already going much longer than the prosecutors asked for, than the prosecutors planned for, than the prosecutors said it would happen in any of the pre-trials. Even then they said it would happen 6 months ago. Like, they have been wrong in all their projections, like a general contractor or weatherman. Like, they've just been completely wrong about everything. So I think limiting them to what they asked for, even like what they asked for, is less time than this is going to end up saying. Okay, let's keep reading here. The state, after originally proposing a list of witnesses, over 700 witnesses, has a list of over 100 witnesses it still intends to present at trial. What specific evidence the state intends to use with each respective witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end to the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed and without bond, and the presentation of another 100 witnesses by the state would cause undue delay, waste of time, and would amount to needless presentation of cumulative evidence. Let's read footnote 2. Here we have the situation described so clearly by Judge Bertelsmann in the oft-cited 1986 decision on limitation imposed at trial. The judge remarks with this insight: it would seem that early in the career of every trial lawyer, he or she has lost a case by leaving something out, and thereupon resolved never again to omit even the most inconsequential item of possible evidence from any future trial. Thereafter, in an excess of caution, the attorney tends to overtry. It says overtry. I was like, that doesn't make sense. Overtry his case by presenting vast quantities of cumulative or marginally relevant evidence. In civil cases, economics place some natural limits on such deals. So what he means by that, the difference between civil and criminal, is both sides are paying for their own trial in the civil case. So we don't want to waste anybody's time. We don't want to waste our client's money. The defense doesn't want to waste their client's money. So there are some different restraints than a prosecutor, who it's very different when they lose, right? They don't have a client they've got to go back for. It should be the people of their state or their jurisdiction. It should be the victims. But a lot of times they don't get fired if they lose. They don't have a client that's going to be ticked off at the end if they lose. They also don't have a client paying them. They have the taxpayers paying them and paying for everything that they need and paying all of their witnesses. So it's very different in a civil and criminal case. The fact that the attorney's fee may not be commensurate with the time required to present the case thrice over imposes some restraint. In a criminal case, however, the prosecution, at least in the federal system, seems not to be subject to such fiscal restraints, and the attorney's enthusiasm for tautology is virtually unchecked. So basically, they're also saying, like, if you have to try a case 3 times as a civil attorney, it's brutal. Everybody would hate that. On a criminal case, for the prosecutors, they'd be like, we're getting paid whether we're trying this case or some other case. Not every prosecutor's like that. I'm just saying that is one of the realities of criminal law. Anything to add? No. All right. As put so succinctly by the Third Circuit Court of Appeals, courts need not allow parties excessive time so as to turn a trial into a circus. After all, a court's resources are finite and a court must dispose of much litigation. In short, the litigants in a particular case do not own the court. Likewise, the prosecution here does not own this honorable court.
Let me stop for a second. Notice that case that they're citing is a civil case, not a criminal case. So when they're talking about the litigants don't own the court, the Constitution does. And therefore, the judge has to be subject to constitutional limitations when they're trying to limit on a criminal case. Those limitations don't apply to a civil case. How many times have we tried civil cases where a judge said, you have 2 weeks and that's it?
All the time. Or limit how long we have for jury selection or all sorts of crazy things.
Right. But you don't hear that in criminal cases because judges really can't cut them off. Again, you can cut them off for cumulative when it happens or all those objections we talked about. But to say in advance, you're cut off at this time really doesn't happen in criminal cases.
So a bunch of people are asking, the defendants have a right to a speedy trial. What happened to that? So the reason that you're not seeing a ton of that yet is they've all waived their right to speedy trial. And once you waive your right to speedy trial, there are certain ways, if you want to talk about that a little bit, like there are certain ways you can still make those arguments if it really goes crazy. Like in Florida, there are people sitting in jail for 20 plus years who have waived their right to speedy trial. And then they make arguments that this has just gone too far, judge. And they've been thrown out, 1 in a million, but 20 years is not always even enough to say that you violated that right to speedy trial. Once it's been waived, it's very hard to kind of backtrack on that.
Right. Well, again, once waived, it's always waived unless you say we withdraw our waiver. You can withdraw the waiver.
Yeah. And then you have a certain number of days from then.
Right.
But that's for the trial to start, not to end.
Right. And then the other is if prosecutors abuse their discretion that cause you the waiver, for instance, they don't give you discovery till the day before the trial starts, which would force you to waive your speedy trial rights. Courts have said that that's unconstitutional, and they've dismissed cases because prosecutors were late giving you discovery.
Yeah.
In this case, it's going to be, if they do anything, which I don't think is going to happen, there are some constitutional cases where there's a constitutional right to a speedy trial, but frankly, this trial has started, and that's the magic date for most speedy trial arguments. Once the trial starts, you have a speedy trial. There's no guarantee of a speedy and short trial. That's not in the Constitution.
Francis said, do the defendants have a choice whether to have a group trial or not? So they can object, but usually it's up to the state to make the initial decision if they want to try them together or not.
And that happened in this case because you had 26 or 28 defendants in this case altogether. They're not all being tried today. Some are being tried in another trial that's going to happen later. So in this case, there was a separation. They subgrouped the group into different trial groups.
Brooklyn Basement said, I made 12 months. Thanks for being consistently dope. You too, Brooklyn Basement. One of my favorite names. Rebecca, if I have learned anything from this channel and Peter, Papa Tragos, and John, it's that they deserve to be heard. I'll save a couple of these other ones till the end of the video. So let's keep reading. This honorable court has broad discretion on the presentation of evidence and should limit the introduction of duplicative or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, OCGA 246611A2 provides the trial court with broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. Newman v. States. It's a criminal case. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a fair trial to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would be cumulative. I mean, obviously, he's not breaking any news here to say you can't call cumulative witnesses. That's not the point. The point is the judge isn't going to know at this point if they're cumulative, right? Upholding the limitation of the number of fact witnesses allowed to be presented to testify to the efficacy of a party's treatment methods. That's a criminal case as well. It sounds like a civil objection. Furthermore, this court can limit the evidence under Rule 403 of our state's rules of evidence. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. And again, in order to do this, the judge would have to make the call that these witnesses are a waste of time and it's causing undue delay. What were you going to say?
Yes, keep in mind in this case, objection, cumulative evidence. All right. When was it cumulative? Well, judge, 2 months ago,
That's true.
so-and-so said so-and-so. Well, this judge is going to sit there and go, okay, can you tell me where in the transcript I would find that? Because I've got to go back and read that. This judge probably is reading a transcript. My guess is she may not have caught up yet to this trial, but the fact that she did not sit there, listen to the original evidence, makes your cumulative objection even more difficult, because you've really got to go through the transcript and show her where in the transcript this was already testified to, so that you can argue that it was cumulative. So these defense lawyers have a double problem when it comes to arguing cumulative.
YouTube Sucks said, I thought Young Thug didn't waive speedy trial. So I don't know. I thought he did. I thought they all did from when this trial started, but whether or not they waive speedy trial doesn't matter, because the trial started, and that's the speedy trial date. Your speedy trial is not when the trial ends. So that's kind of the difference with the speedy trial argument. Furthermore, this court can limit evidence. Oh, sorry, I read that already. Thus, there is also a basis under either Rule 611 or Rule 403 for this court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, or be a needless presentation of cumulative evidence. It has never been supposed that a party has an absolute right to force upon an unwilling tribunal an unending and superfluous mass of testimony limited only by its own judgment and whim. In exercising its reasonable control over the prosecution of a witness and testimony, Kendrick also urges the court to consider ramifications to the present pace of the trial and its impact on the jury, the case, as well as the defendants. While there is no doubt that the new court is moving this case along at the fastest pace possible, given the court's meritorious recognition of the limited recognized right of the state to present its case in the manner that it deems best, the prospect of another 100 witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. There was something I was going to ask you. I should have just stopped. Oh, have you ever had a criminal trial where they've placed a time limit on your case?
Never.
Me neither.
Never.
Civil trials happens all the time, but even then we can usually ask for some leeway, but they're much more strict than in civil trials. And now on the criminal defense side, I mean, we could go on and on if we say, it's our criminal defendant's right to present his evidence here at a trial. But yeah, even as prosecutors, never a time limit. So it is unusual. Mr. Kendrick is not requesting that this is a footnote, that this court limit the number of witnesses that are crucial to the state's case. Speaking to the federal rules of evidence, Rule 403 does not mean that a court may exclude evidence that will cause delay regardless of its probative value. If the evidence is crucial, the judge would abuse discretion in excluding it. And that's kind of the hard part, right? The judge, in order to exclude some of this stuff, would have to make the call that it's either unnecessary, irrelevant, cumulative, prejudicial, causing undue delay, more. Imagine how difficult that would be, Dad. You want to present a witness, and I tell you, Judge, the delay is more prejudicial. I agree that this witness is relevant and probative, but the delay is more prejudicial. How really would you balance that unless the delay was like a year?
No, you can't say that. I mean, you can't, and it's not going to work.
Yeah, it's tough. All right. Courts outside of Georgia and the 11th Circuit have recognized the impact on a jury of a lengthy trial merit consideration. For example, as the 7th Circuit has approvingly quoted, exceedingly lengthy trials lead to reduced concentration and recollection of events on the part of all participants, particularly witnesses and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and representative nature of the jury may be reduced by the fact that many citizens often the most competent, are unable or unwilling to take the time to sit for cases lasting weeks or months. And
Yeah,
when they say something like often the most competent, it's like, yeah, people with jobs and families and responsibilities and are, contributing members of society. It's really hard for them to sit on a case for a year.
There was a case that I was peripherally involved in. Denny McClain, who was a pitcher for the Detroit Tigers years ago, all-star pitcher. He was charged with a case. Judge Kovakovich here was the judge, and this case was going to go long. So what Judge Kovakovich did is she started at 7:30 in the morning, and she went till 6:30 at night in order to get this trial done. The 11th Circuit reversed it, saying you can't make jurors sit there that long, concentrate that long, and not get sleepy and really pay attention. So the 11th Circuit has, and this case is one of them, but the 11th Circuit has made decisions based on the fact that you have fatigued or overdone it with jurors so that jurors weren't able to give you a fair trial. That's happened.
I mean, I can't remember the stuff we watched at the beginning of this case. The lawyers are struggling to remember. The judge is struggling to remember. The jurors who are not, they don't do this for a living and they go back and live their life and they're probably pissed they even have to be involved in this at this point. They're not going to remember that stuff. I mean, I think it's just almost impossible to expect them to remember. Could one or more of the jurors say, I'm done? And if so, what would happen? The judge would have a discussion, ask them questions. Why are you done? You can't just quit. Like, did something pop up? Obviously if the juror really pushed, they would be let go. I mean, what else can you really do at that point?
And, the jurors are, taking notes, but again, this is such a crazy trial. Not only did they take notes and have to remember what did happen, but they've also been told to forget some stuff that have happened. So they've been told, all right, this stuff happened, but forget it. Only remember this stuff. This juror is going to have a heck of a time coming up with a decision.
Yeah, it seems wild.
Yeah, I don't think, frankly, I bet you these defense lawyers in their heart don't want a mistrial. If this case is going to trial, they want this one to be the case.
As mucked up as it could possibly be. If they streamlined it and did it any better, it would just be worse for the defendants. Like
Absolutely.
At this point, they hope the jury forgot half the evidence the state presented.
And you don't think that the prosecution would be better prepared at the next trial since they've already tried this once?
And the defense lawyers have even said, we don't want a mistrial in open court. But I think you're 100% right. And as defense lawyers, you don't want the jury to think about what the prosecutors presented. So if that was months ago and they forget, and then you're making the argument, they didn't present enough evidence to prove this. Well, if you're forgetting some of the evidence they presented as a jury, it's like, yeah, maybe they're right. I don't remember what they did to prove X, Y, or Z.
Keep in mind, this is the state's case they're forgetting.
Exactly.
The state's case is the case that has been going on for 6 months, not the defense case. So if they're forgetting anything, they're forgetting the state's case.
Right. Chris K said, crucial question, Mr. Tragos. When does your son Peter hit 500,000 subscribers? I say by January 2nd.
I agree with you. In fact, I predicted in June that he would hit 500 in January.
I don't know about that. It's a slow roll right now. It's a slow roll. So if you guys have not subscribed, hit the subscribe button, help us get there. Sonny from the H said, Papa Tragos, how much to retain you? That would depend on the case. Also, how proud do you feel of your son following your footsteps? He is sharp, but you are sharper.
Well, I don't know about who's sharp and who's sharper, but
family voice.
Is Siri talking to you?
No, Alexa's talking to me.
Here is your reminder.
Hold on one second.
Family voice.
It'd be over now. Okay. It is, I don't know who's sharper, but I am very proud.
Yeah. Well, I don't know who's sharper either, but I'll say I'll never be as good of a lawyer as he is. I mean, that I think is pretty clear to me. Nicole Wheeler. She's always in the chat. She popped up and gifted 50 memberships. So a bunch of people here for this video will now be new members. So welcome to all the new members. And thank you so much, Nicole, for gifting memberships. You are the best. And I remember the DM you sent recently about she has a class that she learns how to, debate some of these topics and talk about some of this stuff, and some of the videos that we've done can help her with that. So I'm glad that, we'll continue to dig, we'll continue to teach, continue to learn, continue to discuss difficult topics and how they affect society. That's cool. Okay. Adversarial excesses in the American criminal justice, and that's what he's citing. Warner also wrote, jurors become overwhelmed by the volume of evidence and and numbed by its repetitiousness. Their attention flags, their minds wander, the witnesses, there were more than 100 in the trial of the two defendants, get mixed up in the jurors' minds or forgotten. The profusion of exhibits makes the documentary record unintelligible. The impressions created by the closing arguments are likely to wipe out everything that went before. Jury comprehension has been found to diminish after a mere 20 days of trial. The vast majority, I think I've only had 2 or 3 cases that have lasted, I know you've had a lot more than 20 days. The vast majority of trials last less than 20 days. Even today, just across the board, state, federal, civil, criminal, family, doesn't matter. 90+% lasts 20 days or less. Would you agree with that?
Well, maybe more than 90%.
Yeah. So, I mean, so this research, lawyers believe it and lawyers agree with it. And so it's something that they're going to have to deal with in this case. And this is another thing that he brings up a good point here, closing arguments. Closing arguments basically become the end all be all. You explain your case and whoever does better. This could be the case that closing arguments win or lose you the case. And how do you think it's going to go when one of these parties object to facts not in evidence? How do you think that's going to go?
Well, and again, you're going to have to sit around and you're going to have to cite pages of a transcript. One of the things that they cite in this Notre Dame law review makes the documentary evidence record unintelligible. I would hate to be the one doing the appeal in this case. If there is a conviction and I'm hired to do the appeal, can you imagine what the record looks like that you have to read to try to figure out what happened? Okay, we start just the Copeland situation, trying to put together Copeland for a cogent argument to an appellate court. And then these documents, the evidence, even the prosecutors can't get straight what evidence comes in, why, and what the evidence numbers are, and what the dates of the evidence. I don't know how you'd put together an appellate record and do a brief with an appellate record like this. It would be just a nightmare.
Yeah, and you know that they don't cite page and line numbers in closing arguments, so the judge is just going to have to go on her memory and make a call. Like, I wonder if they will literally stop closings to do any of that in this case, just because it's so different. Finally, and not meaning to belabor the point, the court in Warner wisely notes, so now imagine jurors' mental state after 6 months, bearing in mind that memory loss and the psychological or cognitive problems of jurors in a super long trial compound the first problem, the difficulty of recruiting competent jurors for protracted trials. A less intelligible trial is heard by a less capable jury. So basically, what he means here is when we're picking a jury, we tell them how long the case is going to go. So when you say 6 months or a year, that diminishes the jury pool rather than if you do 1 day or 1 week even. Like the vast majority of people can do 1 day. A smaller number, but still a pretty large number, can do 1 week. Once you go past that, it really affects people's lives. The longer the trial, the more likely the jury misconduct, likelier the jury misconduct becomes. The jurors become bored, impatient, irritated. The judge's instruction against discussing the case before the jury retires to deliberate becomes increasingly irksome and likely to be disobeyed. So that's the next question, which is, he's saying there's a higher likelihood that now the jury goes back and does some research and potentially there's some juror misconduct because of how long it's gone, how long they've been out. What do you think about that? I would say it definitely becomes more likely.
Well, it becomes more likely, but I haven't seen that as the problem when you have long trials. I haven't seen where jurors have broken the rules. Jurors, and I think we talked about this in some of your the other videos, but they bond in these long trials. They become really good friends. They go out to lunch after the trial is over. They go to each other's birthday parties after the trial is over. They become really good friends. They talk about their grandchildren. They talk about their vacations. This is a quote, I believe, from actually a Notre Dame law review that a case cited. And I don't know if there's any real evidence or statistical evidence that jurors break the rules based on the length of the trial. Again, that's just my personal feeling. I would disagree with that. They get tired and they can't listen and they can't pay attention, but I think they still try to obey the rules.
I think they try to too, but I mean, to be off for months, to live in Fulton County, And I mean, it would take somebody that, I don't know what I don't want to disparage any religions, but like, religions that don't allow electronics and whatever, like if you have a newspaper, a cell phone, a TV that you watch the news on, how are you not going to see something about the debacle that is this case? And honestly, I feel like it all cuts in favor of the defense, like you said. While the state puts on its case, witness by witness, Kendrick and the other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Meanwhile, the risk of a confused jury unable to comprehend a years-long trial only grows. Wherefore, Mr. Kendrick respectfully requests this honorable court to place a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. And again, I do think there's an element of some people think these guys did it, so they don't feel as bad about that. But just like, I think it was Eric Bland that said in a video we watched, justice has to work for the worst of us in order for it to work for the best of us. And so regardless of what you think about the defendants, about the charges, about the crimes, justice still has to be served in this criminal trial like every criminal trial.
Yeah. There's no saying, and I know this is not a popular saying, but better that 100 men go free than one innocent man go to prison.
Yeah, I've said that a million times on here. So everybody in the chat knows that quote. Ben Franklin. So yeah, that's just how it has to be. I know
Very
it.
good, Peter. I didn't know that was Ben. I didn't know that was Ben Franklin. Very good.
Yeah, I believe I just did it. I just used it in a presentation. I can check.
Oh.
Let me see. Yeah, Ben Franklin. Better 100 guilty persons should escape than one innocent person should suffer. Benjamin Franklin.
Yeah, which I quoted it right.
I used it in a presentation I did recently too. Okay, a couple more questions here. Netwoman said, I have an odd question. Do jury members get paid on these days that drag the case out? Thank you, Papa T, for your insights. Love when you bounce off each other. So no, they don't get paid on days that they're not in court, and they get to go work and live their lives. But they do get their, I always do that after. But they do get their, jury stipend or whatever it is for all the days, which is like literally nothing. Actually, I don't know. Some states and some jobs do pay you, so I guess it could be different. But here, it's like literally nothing. So it's just so difficult to be a juror on a long case like this. Rebecca said, real quick off topic, since Papa Tragos is here, what are your feelings on the Karen Reed debacle? He hasn't been following it as closely as we all have, but I don't know if you have.
That's the Boston case, right? Yeah. Yeah. If I were those prosecutors, I don't know if I'd retry that case. I think they dropped a couple of the charges, right? They've already done that.
But they have not.
Oh, they have. Okay.
The jury's coming back saying we voted 12-0 not guilty on counts 1 and 3, and not on the lesser included of count 2. Manslaughter is what they were discussing. So
yeah, if I were the prosecutors, I would really be concerned about retrying that case and whether it was worth the time and the money, especially when all the law enforcement misconduct that came out of it.
Yeah. Mathis Grease said, how long have you tried an individual criminal case? Yours will be a lot longer. Mine was 5 weeks, federal trial, first federal criminal trial with you.
I've done a couple that were in the 6-month range.
Yeah. Prosecutor always, or some defense too?
Actually, those are all defense.
Okay. All right.
Those are all defense.
Reese's mom, right now these guys are innocent. How can they keep them in jail for so long? Again, if this case was being tried appropriately and the prosecutors were coming up, professionally calling witness after witness and had all the exhibits done, we wouldn't be complaining about it. Because sometimes, like my dad just said, trials take 6 months. Sometimes they take a little bit longer. And unfortunately, if you have a very complex case with a lot of witnesses and a lot of evidence against somebody who's claiming either their innocence or that you can't prove that they're guilty, it's their right to go to trial. Sometimes this does happen, and it happens appropriately, and there's nothing really else we can do about it, right?
Right. And, presuming that they're innocent, I mean, we're not even there yet. I mean, you know how far we are from guilt or innocence in this case? We're not even close.
Sue said a member for 1 year, 11 months, and 3 days. Wow. Almost
and counting.
2 full years. Yeah, and counting. Rebecca, you're a different lawyer than your father. Need not be as good. Don't sell yourself short, Peter. Your daddy raised you right. Well, thank you. And I wasn't trying to sell myself short or have some.
Peter's a really good lawyer.
I was not trying to be overly humble about that. That's like the legitimate truth, which I think everybody would say. But one day maybe we can have a video, maybe a members only live, where we just kind of talk about that, talk about how we're different. A lot of people think we're the same, obviously, because I'm a lawyer, he's a lawyer. We're actually very different. I'm probably more like my mom. we have some similarities as well, but even like the practice and the firm is very different now than it used to be. Just like everything is different, but also together. So it's kind of cool. But yes, very different world, different lawyers, always cool and fun to learn from him. Corey said, good day, sirs. 8th Amendment argument regarding the state's case in chief. Just kidding, gentlemen. Many thanks to you both. Thank you, Corey. And then Laddie Page gifted 5 more Lawyer You Know memberships. A bunch of people gifted memberships throughout the video. So we got a bunch of new members, which is awesome. I appreciate you guys joining us. I appreciate you hanging with us. But that's all we got for this one. We'll keep following this case. Hit that like button if you haven't, and make sure you subscribe. If anybody else is following this case, send them our videos. We love the input and the questions that people have. I'll continue to be on Twitter/X on this case. But until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.